In my mind, I'm gone to Carolina.
Welcome back to What Matters in North Carolina here on the Freedom Action Network. We're having a really good show today here on a Thursday. Beautiful day outside. Glad to have you listening as always. And just a little while ago, the Triangle Business Journal had a lengthy article referencing Representative Dan Bishop, who, as you may or may not know, was the architect of House Bill 2. And he has been given requests by the Business Journal and other media organizations to turn over emails that he has had since shortly before the time that bill was passed. And there's been some challenges there that he and his office have made as to whether or not those emails are actually public records. And to sort through all of this and help us to understand the public records law is Elliot Engstrom. He is the lead counsel with the Civitas Institute Center for Law and Freedom. Elliot, welcome back to the show.
Hello, thanks for having me.
Well, this is kind of a complex issue, but pretty much it's not really that complex because the bottom line is the question, should Representative Bishop, or does he have an obligation to turn over every and all email that is requested?
As far as I can tell from the nature of the request, he does have an obligation to turn over these emails. Because, well, first off, and so what's going on is that he's one of the people who was behind HB2. And, you know, this public records issue is not about, is HB2 good or bad?
Right.
It's about, should we be able to see the conversations legislators were having with each other and with constituents about HB2 using their email addresses? And the answer is absolutely yes. That's what the public records law is. And I haven't been able to find yet in reading the Triangle Business Journal story or in talking to anybody what exemption their office is citing and saying that these aren't public records. I'm honestly a little bit confused at that.
Well, again, just to set this up, there was a lot of response both from the media and from the public surrounding House Bill 2, and the office of Representative Bishop obviously would have received quite a number of emails, and initially a staff member responded to the request for copies of these emails, quoting here now from the story. An aide to Bishop initially declined the request for emails and records related to HB2, asserting, quote, "It is the view of the General Assembly's central staff that public records law does not apply to contact between legislators and constituents." And that's the end of the quote. You're saying that's not necessarily the case.
That's not the case at all. Emails from constituents to legislators are public records. There was a member of the Raleigh City Council who was elected recently who decided that he was going to set up a Gmail account so that constituents would be able to email him and not have the emails be subject to public records law.
Right.
And me and Jonathan Jones of the Open Government Coalition and a bunch of other people quickly called him out and said, you can't do that. And he backed down to his credit. But yeah, I mean, constituent emails to anybody in the government are public records, absent some specific exemption to the public records law. I mean, think about if this was a leftist member of the General Assembly talking to William Barber, okay, right? That'd be public record too.
Yeah.
Right? If they use their email for that. So it's the, you know, I don't want to try to hold, you know, one side to a different standard than the other side. It's you use well, actually, it's not even if you use your government email. You use any email to discuss public business, and that's public record.
Public record. We're talking with Elliot Engstrom of the Civitas Institute Center for Law and Freedom. Now, John, I guess it's Buchan, a partner at Essex Richards, communicated repeatedly with Bishop beginning on May 19th and telling him, look, the public records law says that you need to turn over these emails, and asked the Bishop to cite any legal authority supporting his position. And so far, he's not provided any kind of explanation. However, Tuesday, Bishop's office forwarded 152 messages dating from February 23rd, which is the day after the Charlotte City Council passed that local ordinance expanding non-discrimination protection for gay and transgender people. That's what it says here in the article. I like to think of it more as forcing businesses to comply with a certain ordinance. But nevertheless, as you said, this is really not about HB2. It's about public records. Mm-hmm. So he gives them 152 messages, and he says, quote, I'm furnishing these voluntarily rather than pursuant to the public records law because they don't constitute public records in that they are not made or received pursuant to law or ordinance or are within statutory and or common law legislative privilege. That sounds complex.
Yeah, so that's just not correct. Sorry. I mean, I'm not trying to be a jerk. I'm just saying
no,
that's
I understand.
So there's a phrase in the public records law that says 132-1 defines what a public record is, right? And part of that definition is that a public record is any sort of document or medium or whatever that is made or received pursuant to law or ordinance. And one could read that to say, oh, it means there has to be a law or ordinance that exists that requires you to create this record.
Okay.
That's not how the courts have read it. There was a 1981 case in the North Carolina Court of Appeals where the News and Observer actually sued the Wake County hospital system. And they wanted some documents from the Wake County hospital system. I don't remember exactly what they were. But the hospital system tried to make that exact argument and said, well, the documents they want, we didn't have to create them. Therefore, they're not public records. And the court said verbatim, the phrase in General Statute 132-1, pursuant to law or ordinance, should include, in addition to those records required by law, those records that are kept in carrying out lawful duties. So talking to constituents, a lawful duty. Talking to other people in the government, lawful duty. I mean, and think about the practical ramifications of if you took that interpretation. There's all kinds of communications between people in government all the time that they don't have to make, and none of those would be public records. So that's just not the correct. Now, another thing that he might be doing there is they might just be sort of protecting themselves in the case that there is litigation,
right?
And just giving every possible rationale that these things aren't public records that they could think of. So they said common law, protections, which I don't think those apply anymore in North Carolina, and then any statutory exemption. So he might not even have an exemption in mind. He might just be like, maybe there's one out there. But generally speaking, though, yeah, I mean, I think these things are definitely public records based on what I know of the situation.
Our guest is Elliot Engstrom. He is lead counsel for the Civitas Institute Center for Law and Freedom. Now, Elliot, it's interesting that this article does not mention whether or not records from the city of Charlotte, Senator Bob Rucho, Senator Phil Berger, and Representative Chris Segro have been received. It just mentions that they have sought those records, but they have definitely put Representative Bishop in the crosshairs here in quite a lengthy article. And I worked for a prominent senator over there for 4 years. I can tell you that 152 emails on a controversial issue like this is kind of a low figure. So it's likely that was not all of the email that he received. And he says that, he's sending these voluntarily, and obviously I don't know how many emails he got.
Yeah.
But I can tell you that having worked there, that once the people get wound up about something, they come flooding in. But how do you think this is going to play out? Is this going to end up somebody's going to have to go to court to get his emails?
So and I assume the Triangle Business Journal is the one requesting the documents. So if they're the ones requesting the documents and they think that they haven't gotten everything because he says, I didn't give this to you in response to public records law, I gave it to you voluntarily, then yeah, they might renew their request and say, pursuant to public records law, give us everything. And if it seems like he hasn't given everything, then sure, they could sue under the Public Records Act and say that you have denied our request, right? And that's when he says these were not made pursuant to law or ordinance, and they fall within exemptions, that's a denial of a public records request right there. So yeah, as far as Representative Bishop goes, if he ends up not giving something over and they think there's records, they could sue. In terms of Senator Berger and the city of Charlotte and Mayor Roberts, it's a little dicier with them because my understanding is that TBJ has requested records from them and they just haven't really responded yet. And the law on how long you can take to respond to a public records request is very, very cloudy and foggy in North Carolina. It's just the statute says that government actors must respond to public records requests as promptly as possible.
Okay, so that could be a year.
That's never been litigated ever.
Yeah.
Because anytime I've done this, I've threatened a lawsuit saying, I'm going to sue you. I did this with Chapel Hill. I said, I'm going to sue you and say you have not responded as promptly as possible. And they always just turn it over. So, I guess in theory, I don't think it's been a really long time since they made their original request. Because, the reality is, I don't like this, but the reality is that these people could probably take a few months.
Yeah, well, the House Bill 2 was passed in March.
Yeah.
It's only early June, so we're talking about 2.5 months since the bill's been passed. So, and just to clarify, the article that I'm looking at is in the Triangle Business Journal, but it was actually the Charlotte Business Journal that made those public records requests. But I think they're all part of the same general organization anyway. So here's Representative Bishop. Why wouldn't he just turn it all over? Because here's the thing. We always say, if you don't have anything to hide, that old phrase. So if he doesn't have anything to hide, why not just say, sure, here's my records?
I don't know. Your guess is as good as mine. Maybe he just doesn't, maybe he feels like he's being bullied by the media or something like that. So maybe he's just trying to, stand his ground or something like that. But I would, obviously I'm not his lawyer, but I would probably just give these emails over if it were me. Just rip off the Band-Aid. But unless there's some specific statutory exemption that I'm not aware of that his people know about, that's possible. But I don't know of anything.
Well, yeah, because this is interesting, going back to that statement that his aide said that the central staff of the General Assembly has said that public records law does not apply to contact between legislators and constituents.
Yeah, that's just wrong.
Yeah, I wonder if the General Assembly central staff really did say that.
I don't know. It's summer. Maybe it's slow. Maybe I don't know who's over there. But
well, it's interesting to say the least. It makes for good content on the radio here. And Elliot Engstrom, lead counsel for the Civitas Institute Center for Law and Freedom. So if you were his attorney, it's likely that you would say, look, just do this and get it over with.
Yep. I'd say if I were his attorney, and granted I'm not, but if I were, I'd say, give me all the emails, let me look at them, and then give them over. So that's what I'd say.
Is there any precedent? I think maybe you've answered this already, but requesting emails and stuff from the General Assembly is not something new. Is there any precedent that you can think of where they have refused and have gotten cover for that? Have been able to refuse?
There's exemptions. So for example, the exemptions tend to be pretty specific. There's personnel exemptions. There's one exemption that applies to contracts with carriers and ports off the, so if somebody emailed to somebody in the General Assembly and said, I want a copy of the contracts between your county Port Authority or the North Carolina Port Authority and some company, right, there's an exemption for that. Okay. So they wouldn't have to give that over. But yeah, I'm sure that there's been cases of public records requests that the General Assembly justifiably denied. Sure. Yeah, I'm sure that's happened. But usually it's because it falls within some specific exemption, and that's that. A lot of times it's because people requesting public records don't know what the exemptions are, so they request things that are exempted. But as far as just general correspondences with constituents and stuff like that, yeah, there's no exemption for that I'm aware of. Yeah. Well,
Elliot Engstrom, I can tell you that when I worked down there, a lot of the email that was received came in the form of online petitions where you just put your name there and your email address. Mm-hmm. The body of the email, the text of the email is already written. And I think change.org is one of the organizations where you can just stick your name in there and your address. It'll come up with who is your legislative representative, and then you hit send, and we would get reams of the same email. Yeah. And they all went through these petition sites. So it's likely that if he ever does decide to turn over all of this stuff, they may be getting a mountain of paperwork that has the exact same email in it, that's been composed by one of these websites. But we really appreciate your time here. And I guess we don't really know what the motive is, but I guess behind all of these public records requests, when I worked at a newspaper, I made them. And, you're always looking for something for a story. And I guess that's what they're doing here, trying to find some kind of juicy morsel that will make a big headline.
Yeah, well, it's maybe they need to be looking for communications between the Human Rights Campaign and Jennifer Roberts, but and we've actually seen a few of those, but yeah, I mean, on both sides, you're going to have outside people weighing in. I think what they're likely to find is that most of the outside people weighing in North Carolina didn't jump in until after all the stuff started with Charlotte, and that the Human Rights Campaign was out there communicating with Charlotte on the front end and actually pushed a lot of this stuff. But yeah, that's the kind of stuff you find when you do public records requests. And what you find is that the more people in government especially really understand public records laws, the more you end up having, conversations at Carolina Cafe offline or something like that, because you can't request those. So,
well, let me ask, I just thought of one last thing before we let you go. How deep can this go if there were a particularly significant email that a representative, I'm not even Representative Bishop, but some member in public office didn't want a newspaper, for example, to see, so they delete it, and then they turn over 150 emails or whatever. There's no way of knowing when you receive those that something has been deleted. How far legally can a request for public records go in terms of nosing around deleted emails and that sort of thing? Now, I know they're not supposed to delete them.
You're not supposed to delete them, and you run into the same problem in discovery in lawsuits where you're suing two companies suing each other, and they say give us all the emails, right? In discovery in a civil lawsuit, deleting that email is a felony.
Wow.
I don't know if that's the case under public records law. I don't think it is, which is probably a concern that should be addressed. But yeah, I mean, so if you think they've deleted emails, you can renew your request and say, I think you've deleted emails. I want to see, I want you to send me backup hard drives. I want you to send me all kinds of other stuff. And then, also there's, the Department of Cultural Resources prescribes how long government entities have to hold on to documents, And so if it turns out that they had documents and they didn't hold on to them long enough, then the story is they're getting rid of emails. And, maybe the idea is that the check there is a democratic process instead of criminal law like it is in civil court. But yeah, I mean, it is the truth, though, is that in public records law, there is some element of good faith, right? That if you request records from somebody in government, they're not just going to go torch them, you know?
Yeah, exactly.
I mean, that's now, how do you draft a better law? That's a good question.
Well, you're the lawyer, Elliot. You gotta come up with these ideas.
There are some ideas. One idea is to have a database that emails just go into.
Yeah.
And then you have attorneys review them as they go in. And so that way nobody can delete emails. But there's a few different ideas. Each one has its own little kinks. But yeah, I mean, it's something you'd be amazed. It seems to us like the internet's been around for so long now, but it's really only been 20 years-ish?
Yeah.
And the law still hasn't caught up.
Yeah.
So, yeah.
Well, I'll leave you with this kind of a little funny anecdote, and this is how you solve all of this problem. His name escapes me, but there was an older senator there when I worked there, and the word around the General Assembly was that he had never responded to an email.
Wow.
And there were literally 10,000 or more emails in his inbox. And so there would be no public records regarding emails for this particular member of the Senate to get in trouble with, because he just, he was an older guy and didn't do it. So
that's funny.
That was kind of humorous at the time. Elliot Engstrom, thank you very much for being our guest here on What Matters in North Carolina.
All right, thank you.